if a plan says, we have recovery from any automobile policy, that does not mean that automobile policy includes UIM. Now, where it gets tricky is sometimes these plans will say underinsured or uninsured motorists. They'll say that very clearly. And so they'll say, hey, no, our plain language says we can recover from that. And so because it says that, we can't. And that's where we often push back and say, listen, just because you put it in your contract does not mean it's true. You have to review the plain language through also all of this case law. And there is nothing out there very clearly that says you can recover from UIM settlements. So because it's not, we're oftentimes using bits and pieces of different cases to try to at least sow enough doubt that they might realize, okay, they might be right here, or it's not worth pursuing this beyond this negotiation phase, because potentially we could lose and we could create settled law that says, oh no, you can't recover from UIM, even if your contract says it.
Howdy, and welcome to the show. Cooper's Code focuses on legal issues and notable practitioners, distilling wisdom so we all achieve the best results for our clients. I'm Miles Cooper, and I'm very excited for this lien reduction strategy episode with Tim Michael, Pre-Litigation Manager at Cooper's and Lien Jedi Master. Some folks do crossword puzzles or Wordle. Tim seems to have found his happy place in finding inconsistencies between health insurance contracts and the statutes they seek to avoid when claiming an interest in our clients' recoveries. We discuss some ways to tackle liens, as well as private equity's consolidation of the lien recovery industry and what that might mean going forward. So please sit back and enjoy this deep dive into liens. Welcome back to the show, Tim.
Thanks for having me.
I appreciate you being here. And for those who don't remember, because it's been quite a while since Tim was last on, Tim is our pre-litigation manager at Cooper's, but Tim also is quite the lien guru. And because we covered some material recently in an article that was well received, I suggested, Tim, that you come back on the show and kind of help walk us through some of the things that you've learned doing all of the lien research that you've done. Is that fair?
Yep. No, that sounds good. It's a fascinating area that oftentimes doesn't get enough coverage in my mind. So,
and to be fair, I think, and I made the joke with the read-in terms of the types of people who are attracted to this. Oftentimes, the same people who like crossword puzzles and Wordle and complicated knitting patterns. It is interesting, but it's also, in certain respects, somewhat technical. Is that fair?
Absolutely. Yeah, I mean, it's very technical, but eventually you start putting the elements together and you realize it's fairly formulaic, right? And so when you're just kind of getting into it, it can be kind of daunting, and there's different types of plans and different, things to consider. But then eventually it does become pretty formulaic, and you start just seeing the same things over and over, and just have to address them that specific way for the various different requirements.
Since we have a variety of listeners who tune in from the very sophisticated to the very novice, let's just touch quickly on what liens are, and here we're primarily discussing health insurance liens and why they are so important in terms of being negotiated in a case.
Most people who are injured, they have health insurance, and their health insurance covers their medical treatment. And what people generally don't realize is that if you are injured by somebody else and you receive an insurance settlement for that injury, then your health insurance company oftentimes has a right to be reimbursed for the amount they paid for your medical treatment. And so again, I referenced that most people are unaware, because that is something we find over and over again with clients, is when we're walking them through the process. And one of the first things we tell clients is, you are going to have to pay back Kaiser or Blue Shield of California for the medical treatment they paid for. They sometimes are like, whoa, why do I have to do that? I pay my insurance premiums. I do all of this. Why do they get paid back? And so then there's a long conversation that comes from that. But it's fascinating because we also use that limited knowledge that people have about health insurance liens sometimes to our benefit when we're negotiating the lien. And I'm sure we'll get into that a little bit later. So, that generally is what a lien is. And the reason, at least we find them so important, and is that Oftentimes they take up a large chunk of a client's recovery, especially when the health insurance company asserts the lien. It's generally a large number that will be a significant portion of a settlement. And so after you account for fees and costs, you then take the lien off of the net after fees and costs. And sometimes it could leave the client with, a small share of the total settlement. So what we find is negotiating those liens is really important, because if you can get a huge reduction for your client, every single dollar you get reduced goes to the client. But that also causes a little bit of tension between the firm and, representing the client's best interest, because if you're going to spend a ton of time negotiating this lien, it's not going to increase your firm's recovery, but it will ultimately increase your client's recovery. And so, finding that time and being willing to put in that effort is something we find valuable, but I'm not sure all firms necessarily see that value.
There are two tracks I'm going to go down here with this. I want to come back to the value and the firms that do this versus the firms who may not push it as hard. I'm going to set that aside for a moment. I do want to talk about expectation setting. Do you find that it's helpful to bring this up initially with a new client or potential client so that they're aware that this thing is lingering out there? Because I think a lot of people, when they arrive at a firm, they've got this, if they've never had a personal injury case before, they've got this idea in their mind that people get millions of dollars for a hangnail, and you have to kind of educate them on it's not as much as you think, and the money goes in different places. Is that fair?
Totally fair. And we bring up health insurance liens very early on in the process. So generally, when a client is still going through the intake process, so they haven't even signed with the firm, we make sure that they are aware that this is going to potentially, eat up a large portion of the settlement, but also make them aware that we will do our best to reduce that lien. But we think that's important because, if you don't share that information with them, sometimes you end up with a client who is already signed, and then they're like, wait a minute, so now I have to reimburse my health insurance and I have to go through this whole process. Maybe that client would rather just not even pursue the case anyways, because they don't want to have to just deal with the process just to reimburse their health insurance. But you can also settle those, concerns with the client early on, so that way their expectations are properly set. You don't run into an issue where they've gone through the process for 18 months and suddenly when you're sending them the final settlement breakdown and they're like, whoa, where's that money going? That is when you really have yourself a problem. So we make sure to talk about the health insurance lien, not just at intake, but also first client call with the case manager or attorney. And then, every, month or two from there, just keeping them updated on the amount of the lien, things of that sort.
With that said, I want to return to the fiduciary duty to the client and what I would describe as the more global duty to our trade. And here's what I mean by that. As lawyers, we have a fiduciary duty to our clients to do the best possible job for them. And so, and I think you outlined this already, but it bears repeating. The lien money comes out of the client's net. So if it's a $20,000 lien and the client's net is $66,000, that 20 comes out of the 66, and every dollar you save for the dollar that they get. We have a duty to try and reduce it as much as possible. But on the trade, the brethren, whatever you want to call it, have you run into challenges with health insurance recovery companies because there are some firms who do not push for their clients and just take whatever the number is?
I have not necessarily heard from an analyst at Rawlings or an Equian, the large lien holders that are recovery agencies that pursue these liens on behalf of the health insurance clients. I've not heard from the analyst specifically like, oh no, all of these firms just would pay this whole amount. They don't say it, but you can tell based on the way they handle the negotiation that oftentimes they're surprised to get pushback. And so when you do pushback, they'll sometimes say, you know, I've never heard this before, or something along those lines. And so what you can't help but eventually feel is that there are firms out there who just, for example, certain plans have a standard reduction. Maybe the lien holder says, listen, yeah, you know, you have a $30,000 settlement. We have a $20,000 lien. We'll only take a third of the settlement. We'll just split the settlement 3 ways, 1/3, 1/3, 1/3. And so they'll accept 10,000, and those firms will just say, you know what? Yes. All right. We'll take that and we'll be done. And it feels maybe like a bit of a win because they are getting a reduction, but they're getting a reduction that they're entitled to under the law, that's very clearly laid out. But sometimes you can push harder than that and get a further reduction, but you can tell they're resistant to give it because probably more often than not, the firms are just accepting that standard reduction and not trying to take a unique angle to get a better recovery.
To be clear, when you're talking about pushing is being creative. It's looking at contract language. It's looking at statutes. It's looking at various ways that one can legitimately point to the health care recovery entity that no, you're not entitled to all of that, and this is why.
Exactly. And, you know, so that's why when you're evaluating the lien for potential, you know, reduction angles, one of the things you ask for is the plan language, because that is one of the most important things when considering, you know, avenues for a reduction. And going back to that previous comment, one of the ways you can tell that, you know, these lien holders are used to law firms just accepting like a standard reduction of something of that sort is we asked for the plan language in every single case. And it's critical that you get the full plan language. You don't just want the section that says subrogation and reimbursement. You need the entire thing so you can evaluate where that section is in the plan, how they call the insured's attention to that section, all of that. But oftentimes, probably over 75% of the time, when you ask for the full plan language, they'll still just send you that little excerpt. And, you know, I'm sure there are plenty of firms out there that are like, okay, great, thanks for that excerpt. But you need to see the entire thing if you're going to, you know, properly attack, you know, the plan language. And so, you know, just by them oftentimes not providing that whole thing, even when you ask for it, you have to sometimes ask a second time. No, I don't want just that subsection. I want the entire plan. You can tell that that's not always a common request from other firms.
When you ask for that, are there various ways that you ask? Are you asking for it from Rawlings or Equian, or do you have the client sometimes go to their benefit administrator to get the plan?
So, you know, there are various ways. I usually start with, you know, the analyst at Rawlings, Equian, whatever it may be. They are supposed to have everything. They're supposed to have plan language. There's this thing called Form 5500. They often carry that. And there's also, you know, a lot of people, when they think of their health insurance, they think of the summary of benefits and covers, the SBC, which is that little like 8-page that just clearly outlines here's what you'll pay for different types of things. That can also be useful. And sometimes they'll just try to provide that. But what the most important in our view is the full plan language, which is either called an evidence of coverage. It's called an evidence of coverage if it's a, you know, fully funded, fully insured plan. It's called a summary plan description, or an SPD. If it usually that's the title of it if it is a self-funded ERISA plan. And so, you know, usually if I know it's self-funded ERISA, I'll say provide a copy of the summary plan description. If you don't yet know what it is, I'll say please provide either the evidence of coverage or the summary plan description, and they'll provide it. Oftentimes. Sometimes they'll say, oh, we have to get it from the plan first. And then, you know, that can take weeks, sometimes months. Sometimes you have to keep pushing back. I need this plan language. We're not going to be able to, you know, resolve this lien until we have it. And in those situations, sometimes we will go to the client and say, listen, you have Blue Shield, you know, go on to the app. You can scroll down to documents, click on, you know, evidence of coverage, and just download that and send it to me. And again, it's shocking how few people realize that they have access to that document and that document actually will impact their benefits under the plan. And so oftentimes they see it and they're like, wow, I've never seen this before. And it's a 100-page document that outlines, how your health insurance functions essentially. So
we've talked a little bit about liens, what they are, what they're governed in terms of documentation. And as we worked on this most recent article, I ended up going down a little bit of a rabbit hole. And so rather than Q&A with you on this, I'm going to go through some of what I found, which I thought was really interesting. So historically, these companies have been, Equian also had a relational entity called Sharps and Associates way back in the day, which was kind of their litigation arm. Then there was the Rawlings company. There was Optum, and you're hearing me say was, as in past tense. And the reason I'm saying past tense is, and I'm sorry, I'm mid-thought going to ask you a question. I know that some of these entities were from Kentucky and those areas. Are all of them from that area? Do you know? Are they all kind of like offshoots of the same folks?
I do believe, off the top of my head, I certainly know Rawlings is in Kentucky, somewhere between Lexington and Louisville. I'm from Kentucky originally, so anytime I see the address, it always sticks out to me. But so I know Rawlings was based there, and I believe still is based there, but even though they've moved towards a more remote. But I believe also Equian is there. I don't think Optum is in Kentucky.
Okay.
And I've never fully understood why they're all in Kentucky, but it seems to be a place for them. So.
It bears stating that while you are from Kentucky and you have granular knowledge of liens, you are not a Rawlings hire. Meaning you came to our firm with no
Correct.
Prior background in liens or anything. It's just coincidental that you're from Kentucky.
Correct. Yes.
Okay. Well, so one of the things, and I think you were the one who kind of got me going down this rabbit hole. You mentioned that one of the entities was now calling itself Katch, Katch, and that was Optum, if I recall correctly.
Equian at some point became Optum, and then Equian and Optum are together under the Katch umbrella now.
Okay. And then Rawlings, I think, is now Machinify. Is that
correct? Yeah. And Machinify is, 5 other companies kind of wrapped up into one of those 5 being Rawlings.
And as you start kind of drilling down into who are these entities, why are their names changing, why is Kaiser's entity that used to be Equian now Rawlings, but actually Rawlings is Machinify. And for those who can't really follow the 3-card Monty, we're going to cut to the chase, which is that a private equity company called New Mountain Capital appears to now have controlling interests in the majority of the lien recovery entities out there. So that would be what were previously known as Optum, Equian, and Rawlings, now Katch and Machinify. And if you start digging into some of the websites for these entities, they're talking about using AI and other tools to start breaking down this information to be much more thorough and granular in terms of making sure that they recover assets for their owners. Is that fair?
That is fair. Yes. And you mentioned a lot of the recovery agencies. So Optum, Equian, Rawlings, those have historically been the largest. Rawlings is probably the most recognized name in the industry. And the few that have not gone down that path, you may recognize as like Carillon, which is a relatively small recovery agency. And then you've also got like FIA Group, which is a much lesser known entity. So
the reason we bring this up is because these shifts are relatively new, and typically when private equity comes in, they're looking to streamline industries and improve returns on investment. So it is entirely possible that we'll be seeing some shifts in approaches, whether they be more aggressive, whether they are less people oriented, whatever it may be. Expect change is kind of what I am thinking when I see this level of consolidation.
Absolutely. And it's going to be very fascinating to see what that will be. I've been thinking about it a lot. And, to some level, you would expect maybe because they're under private equity, they'll be a little more aggressive. But I also feel like there could be some benefit for, the plaintiff community in that maybe some of the smaller, less valuable liens will get less attention. Right. They'll pick and choose their battles. If you're trying to optimize, maybe don't be going after those $2,000 liens and spend, months negotiating back and forth on those. Spend that time on those $100,000, $200,000 liens. And so then maybe we'll be better off when it comes to negotiating those smaller liens. Who knows? It's time will tell. But maybe that's just my optimistic hope for how things will go.
I think one of the things that was also interesting as we're doing this deep dive is seeing how some of the entities are starting to use AI to scroll through social media. And this is more of a concern for unrepresented individuals than represented clients, but people who may receive a settlement but not do anything related to the letter that they get from their health insurance recovery company. Those companies are now using tools to identify people who may have not turned over all the information. And that can get dicey for them because one of the things they can do is they can cut off benefits if you choose not to engage with them in terms of the reimbursement side. So one of the other things that's interesting is while all of these have been consolidated under one private equity holding, there are still some, I'll call it, organizational behavior differences. And here we're starting to get into Kaiser. As I understand it, one of the shifts is that Rawlings took over lien recovery from Kaiser within the last year.
I believe it was January 1st, 2025 is when.
Okay.
Yeah. So it's now been a little over a year.
And what was one of the things that you noticed when Rawlings took over in terms of aggressiveness and interest in UIM, uninsured, underinsured motorist coverage that previously, Equine had kind of followed the law on?
It's funny because we historically have thought of Kaiser as one of the better plans because when they were under Equine, you knew that no matter what, they were only going to seek recovery from a third party claim. So, when we run into the situation where, the third party defendant, the defendant only has $15,000 policy, we get that, but then our client thankfully has a $250K UIM. If there's a $100,000 lien, they're still going to only accept $5,000. They're going to do the 30/40 reduction, accept the $5,000 from the third party, and the lien will be done. And then you can just go after the UIM. That was always really great. And then we always had an issue with Rawlings because Rawlings, without fail, would seek from UIM recoveries, and, for various different plans. Blue Shield of California is the one that comes to mind. And so when we found out that Kaiser was moving over to Rawlings, it was a little bit of a concern. Oh, why are they making this change? And then will Rawlings start seeking recovery from UIM or reimbursement from UIM, just solely because they're handling the Kaiser plan? And so that's where I did a little bit of digging. I'd start talking to some of these analysts and I'd say, hey, listen, back when this lien was with Equine, we knew they would not seek UIM recovery. How are you guys going to handle this? And they said that, they intend to seek reimbursement from UIM. Now, fascinatingly, Rawlings has not yet done that in every single situation. So if you have a case from prior to 2025, so if the date of loss was even December 30th, 2024, the Rawlings will still usually say, you're right, we will not seek recovery from UIM. Now, as we kind of are getting close to that time where we're resolving more 2025 cases, we've seen a few where they're seeking that reimbursement from UIM. We've also seen a few where they just say, no, we're only seeking third party. So it's kind of unclear. It doesn't seem like it's a firm policy that they're certainly doing it, but they are moving in that direction and there's uncertainty there, where previously you just knew if you had a Kaiser plan, it was going to be third party. third party only.
As you work on some of these strategies, are there, and I feel the need to cover this, while you are a pre-litigation manager and you're going to be going to law school, you are not a lawyer. So the conversation we're having, I am one. The conversation we're having is one in which you've done a lot of the detail work. You have a lot of granularity. We work together in terms of the negotiations strategy and how we handle these things, because we are careful that you are not playing a lawyer on TV. But with that said, because of your granularity, I think you have more knowledge of some of the case law, and some of the tools that you've found to build letters to send to the health insurance carriers, the Rawlings, et cetera, to try to negotiate some of these. So can you walk us through some of this?
Yeah. And, I should say at the outset, I don't want to take full credit, and I think we'll kind of touch on this later, but there are some other lien experts out there who are great resources for information. And a lot of this, or at least, the foundation of this I get from them. And then, they often provide letters. Don DeCamera is the one that I'm most familiar with, and some of his letters that he has shared at Lien seminars and things of that sort of talks.
So I'm going to interrupt you because I do want to give a plug. And here's what I mean by that. Sometimes some of these liens are so complicated where really it pays to bring in a specialist. And Don DeCamera is one. There are many others out there. I'm parroting what you're saying, but I'm going to add on to it, which is bringing people like that in and paying them for their time helps make sure that the knowledge that they build and then share with all of us continues to be banked. So when you have one of those complicated cases, do think about reaching out to one of those people who do give back to the greater good of the community. And Don is definitely one of those.
Absolutely. I'd seen this in some of the papers that he gives out at his talks, and UIM recovery is a very interesting area because, it does not seem reasonable. Just if you're just thinking about it from, a layman's perspective, it does not seem reasonable that a health insurance company should be entitled to reimbursement from UIM coverage that you pay for out of your own pocket. So, you could have two people, same injuries, same situation, one with UIM, one without. And just because I made the decision, let's say I'm the one with UM, just because I made the decision to pay for that, now I owe my health insurance company more money because I was wise enough to have healthy limits. That just seems unreasonable, at face value. And so, there's that, but then there is some case law out there that, will make you question. One is, Boston Mutual versus Murphy. It's a Ninth Circuit case. And, it essentially says, there's one part in there that, I find really interesting. And it's that, no reasonable insured would expect that the plan's coordination clause, which at most implicates other first party medical coverage, could possibly apply to UIM coverage. Right. So, the idea being, if a plan says, we have recovery from any automobile policy, that does not mean that automobile policy includes UIM. Now, where it gets tricky is sometimes these plans will say underinsured or uninsured motorists. They'll say that very clearly. And so they'll say, hey, no, our plan language says we can recover from that. And so because it says that, we can't. And that's where we often push back and say, listen, just because you put it in your contract does not mean it's true. You are, essentially you have to review the plain language through also all of this case law. And it says that, there is nothing out there very clearly that says you can recover from UIM settlements. So because it's not, we're oftentimes using bits and pieces of different cases to try to at least sow enough doubt that they might realize, okay, they might be right here, or it's not worth pursuing this, beyond this negotiation phase, because potentially we could lose, and we could create settled law that says, oh no, you can't recover from UIM, even if your contract says it. So that's Boston Mutual. And then the other one being St. Paul Fire and versus Murray Plumbing and Heating. And that's just got some like additional language related to that. And it kind of says that insurers cannot exercise subrogation rights against their own insureds or co-insureds. And so again, it's maybe not exactly on point, but what you think about is if I'm insured by my health insurance and my auto insurance, even though they're different coverages, they cannot exercise subrogation rights against, their own insured or co-insured. So in this case, it would be a co-insured relationship. So that's the idea. Oftentimes it's just letters to like Blue Shield of California, for example, just showing that you're at least aware of this, you're thinking about this. And it does not mean they'll just outright waive the lien or recovery from UIM, but oftentimes you can get them to accept like pennies on the dollar if you're very aggressive about it and continue to just fight it until one of the sides folds. And so we just try to make sure it's the health insurance company that folds first.
So what I'm hearing, multiple rounds of letters, multiple pushing, and you just kind of, if you're firm and you hold the line, you can do a good job in terms of reducing the lien far more than one might think.
Yeah, and that's just lien negotiation generally, but also related to UIM. What I think of is like wrongful recovery against UIM. I think what they're doing is just generally saying we can do this, and they say it enough, and then eventually people just pay it, and so then that kind of emboldens them to think, oh no, you do owe us on this. Other people are doing it, and so their hope is that they can just keep saying, no, you must pay it. It says it right here. They say the same thing over and over again, hoping you'll eventually just get so tired of this, because after all, even if you get them to agree with you, you as the law firm are not going to increase your, fee on the case. And so they're hoping you'll eventually fold. Whereas, we're hoping they'll eventually just agree. Okay, fine. We'll take a significant reduction just to get this wrapped up and over with.
Since you mentioned the cases, I'll give the sites, but I'll also let people know that we'll drop the actual sites and cases into the show notes. Boston Mutual is 242 F 3rd 899. The St. Paul Fire and Marine Insurance versus Murray Plumbing and Heating Corp is 65 Calap 3rd 66. So those are the two cases that you were just referencing. I'm going to take a little bit of a tangent, and that is what gets done with this money while the letters are going back and forth. How do law firms, auto insurance payers, whoever it is, handle the funds to make sure that they are sequestered appropriately and not handed out, say, to clients and then having to turn around and say, oh, that money that we gave you, we need it back?
Our hope generally is that an auto insurance company will just cut a check to the law firm and the client and leave the health insurance off the check as a payee. Sometimes they'll try to insist, no, we must include them. Generally speaking, they only need to do that if it's a statutory lien, something like, Medicare, Medi-Cal. Sometimes they'll want to include them on there, or they'll want to send them the check directly. That's fine, because those negotiations are very different than kind of what we're talking about here. Those have a more sorted out, way of handling. And so the liens where we often are going to be in this month-long negotiation process, we usually get a check without the health insurance company listed as payee. So then we can go ahead and put it in the attorney-client trust account. And then we'll go ahead and disperse, what we can while withholding the entire health insurance line. So, say you have a $100,000 settlement, $35,000 lien, you'll disperse fees, costs, and, net settlement to the client less that $35,000. You'll hold on to that $35,000 and then keep negotiating until you get a resolution, and eventually cut a check to the health insurer and then send the rest on to the client. And, we do that because it's one, clients want to get their settlement oftentimes as soon as they can. So we gift them what we can and then tell them, which oftentimes gives them, a little, it'll kind of get them to realize, okay, it's okay now. I can give it several months, let them take their time because, worst case scenario, I'm getting nothing more. Best case scenario, I'm getting, tens of thousands of dollars more, depending on how this all pans out. So that's how we usually handle it.
Well, it's truly only the client's money that we're fighting over. Sometimes without that ability to get some recovery, the clients will not have the moxie for the fight, I guess would be the way to put it.
Absolutely. Yeah. So, and that's kind of what we've learned over time is if we say to a client, hey, we can't disperse yet. We're still wrapping up the health insurance lien. And we're like, and I've had this conversation dozens of times with clients, like, if you will give us the time, we're willing to put in the time to try to get, this reduced as far as we can. And if you tell them that they will get some of the settlement before we go through that process, they're much more willing. Sometimes they'll be like, no, I want to be done with this. It already took 18 months to get to this settlement and I just want to be done. But when they realize, you can either be done and just get that amount, or we can give you that amount and you can give us several months and, it does not take much of your involvement. We're not going to be following up with you regularly. We'll send you updates. And usually the client will be like, okay, great. That sounds good. And then they're very happy when, 3 months down the road, you're able to send them an additional $5,000, $10,000 that, they may at that point have already expected to just all go to the health insurance company. So nice little surprise at the end sometimes.
I'll make a statement here since you brought up the statutory liens. We are not covering statutory liens, things like all board reductions. We did that on a prior episode. That was with Hendrik White, and that was a couple of years back, I believe. But you can find that, and we did cover some strategies for that as well on a different episode.
I think that may have been the second ever episode.
The benefit of being young is that your memory is better than mine. So you would think it being my show, I'd remember that, but there it is. Let's get involved in an additional strategy that you've used, and this is the medical payments strategy, and this involves situations where there is a medical payment portion on an auto insurance policy, and with that, just take it away.
At least on our pre-litigation team, we often call this like the MedPay shuffle. And, in California, it's relatively rare that a client has medical payments coverage, but, you see it on occasion. I would say, maybe 25% of cases, if that. But you see it. And for those that don't know, medical payments is a no-fault coverage that will cover your medical expenses. So, you have it through your own auto policy. And if you get injured and your health insurance may be covering, most of the bills, but you might have a $500 deductible or a $500 copay, your medical payments coverage will cover that copay or deductible. And because oftentimes you have health insurance covering it, you don't always exhaust that medical payments coverage. So, I'd say the standard medical payments coverage, if somebody has it, is $5,000. Occasionally you'll see 10. Rarely you'll see 25,000. But oftentimes by the time you're reaching the end of the case, you've spent only a fraction of the entire medical payments coverage because your health insurance is covering most of it. So then what you do is you go to the health insurance lien holder and you negotiate that down as much as you can. Usually, if we're just doing a fairly standard reduction, and it's, subject to 30/40, so fully funded, fully insured plan, you get fees and costs taken off of the top of the health insurance lien. So let's just say 33 1/3, for example, a ballpark 33 1/3 gets shaved off the top. So by way of example, $10,000 lien, Rawlings says, okay, we'll shave off the 33 1/3. We'll accept 6,500, we'll call it. Now, you go to your medical payments, adjuster. So through the auto insurance and say, listen, we're going to owe this $6,500 to Rawlings. Can you cut a check, please? And so they will then cut a check, pay them. And then oftentimes the, MedPay has a lien against your settlement as well. So that's a second lien, and you're sitting there thinking, okay, well now I've increased my lien by $6,500. How does that help me at all? But they also have to reduce for fees and costs. So now that $6,500, you get another 33 and a third shaved off. And now you're looking at 4,200. And so, that $10,000 lien, which without the MedPay may have been 6,600 is now like 4,000 because you've had MedPay, cover it and you've been able to reduce that. Now, what can really be beneficial is, generally speaking, if your recovery from the third party is policy limits. So if you get a policy limit recovery, the client was not made whole, or you can make some sort of argument that the client was not made whole. The medical payment lien should be waived. Now, oftentimes they'll push back on that. I'll usually say, listen, we got the third party policy, we got the limits. Client was not made whole. You guys have to waive the medical payments lien. And they'll say, no, we don't. We can recover. And then you just ask them for the contract language of the auto plan. And you'll find that under the, subrogation reimbursement section, they do not waive made whole. And so whereas health insurance companies almost always waive the made whole in their plan language, medical payments, they have not caught on to that and they do not include it. And almost always they'll waive it.
Fingers crossed here. I did get a text from a lawyer friend of mine that he has an adjuster friend who has started listening and likes the show. So I've just got fingers crossed that this is not going to go up the claims levels and all of a sudden we're going to see AAA writing this in. But, who knows? Better to share the knowledge.
Exactly. Yeah, we'll have to see. And along those lines with the waiving the medical payments lien because you were not made whole, if they won't do that, or if they can demonstrate that they do waive made whole in the plan language, whatever it may be, we'll often use the argument, my client has been a AAA insured for 25 years. They rarely make claims. And sometimes we do this with UIM negotiations too, but it really seems to work in MedPay because, it's a no-fault coverage. It's supposed to be there. My client never uses it. They've, paid their premiums on time for 25 years. Do you really need that $4,000 or can you just waive it? And oftentimes they'll say, okay, fine, we'll waive it, or they'll accept 500 or something like that. So, there's various different ways to handle the MedPay lien negotiation, and they usually are much easier negotiations than the health insurance liens. They just tend to be a little less aggressive and, they seem a little less passionate about actually recovering the full value of their lien than the Rawlings and Equians or Katches of the world. So
we'll see what happens when New Mountain Capital acquires the subrogation rights as well.
Exactly.
For those who are not on the video version, I'm now grinning because I'm being a little glib about that one. Pivoting now into causation, are there situations where you find that the causation defense that, the ACL tear, the whatever, the disc degeneration, whatever it is, was not caused by this collision? Are there times where you find that the defense reports or the defense efforts in the case to minimize that then become beneficial in the lien negotiation? And if so, how?
Absolutely. So, I'll be honest, we see less of this on the pre-litigation side in my department, but I am aware that this is a common strategy our friends in our litigation department use. And, it's important to recognize that when you are about to negotiate a lien, it is important to get the itemized statement of benefits and see what they are claiming. So, sometimes, generally speaking, when you report the lien, they'll ask what are the injuries, what body parts. And so that way they can code it in such a way that they only get what they think is the incident related treatment. You should always go through that and make sure they're not including anything that was not related, which sometimes happens. But then what you'll realize is when you're, litigating a case, the defense might say, using your ACL example, oh no, that ACL was already, torn prior to this incident. And it was not this incident that caused that ACL tear, despite, the plaintiff's expert saying so. And so as soon as you resolve the case, you then turn around, go back to Rawlings, for example, and say, look, here is a report from an expert that says that this injury was not related to the incident. So you guys must take off all treatment related to the ACL repair, imaging, everything. And then they'll say, all right, we'll shave that off. They take it off. And then oftentimes your lien gets cut down by a huge amount. And I will say, generally speaking, if you ask the lien holder to take certain claims off, you don't get a lot of pushback or a lot of, they're generally willing to do it. Now, some of these more complex issues where, we actually do think it is related, but, there's an argument that it is not. That's where it's helpful to have that support, like an expert report from the defense experts. But yeah, we've had good success there and have gotten some huge liens, reduced by a significant amount. And obviously that totally benefits the client.
As we kind of come into the end of things, so to speak, are there any other major strategies, major practice points that we haven't covered that you think we should dive into?
There's not a whole lot. One of the things that comes to mind, and if you have experience with liens, you're probably well aware of this, but we didn't really cover the difference between a self-funded and like a fully insured plan where, the self-funded, they're entitled to a larger portion of the full lien recovery. They oftentimes don't have to reduce for fees, attorney's fees or costs. There's not some California 30/40, automatic calculation. They oftentimes say we're entitled to the full amount of our lien and we intend to recover that amount. And because of that, it is important to recognize that you should be negotiating those liens early. What I've found is it's helpful to not send in a release before releasing the third party and, accepting a settlement, go to the lien holder and say something along the lines of, look, we're being offered a policy. They're offering the policy limits, but I recognize you're going to try to take, 60% of that. And our client, doesn't want to do that. And so either they're thinking about walking away, whether that's true or not, you say it, they're thinking about walking away, or, if you guys aren't willing to reduce, then the client's not going to accept this and they're going to want to file. And then we're going to end up spending all this time and money seeking a personal contribution that might ultimately end up with no additional recovery. And so you guys are going to wait 2 years to get the money that you're looking for right now. And, we'll give you 60% of what you're looking for now, this week, if you're willing to, make that reduction. So there's just certain angles that you need to take, especially with regard to the self-funded ERISA liens, because otherwise they can be very aggressive and try to seek, the full amount. And so it's just important to kind of negotiate early prior to resolving the case. So that way you can have a little bit more leverage with them.
And I've seen self-funded ERISA carriers play chicken with that. And in situations where our clients truly did not want to be a pass-through, where it wasn't until the day before the statute of limitations was running that we were able to ink a deal, a pre-filing deal as to what the breakdown was going to be. And there are a few notably aggressive self-funded ERISA plans out there that on occasion some of us have the misfortune of coming across. So one other strategy that came up in talking with another lawyer that I'll throw out there, it's not one that we generally employ, but it is within the arsenal. And so I'm just going to list it as a possibility. It can be challenging for the bookkeeper, and it can be challenging just from a duration perspective. But there are some lawyers who use the statute solution. And the statute solution is you got somebody who's just completely pig-headed, and you park the money. And you park the money until the statute runs, because usually they won't do anything about it. And then you release the funds to the client once the statute is passed. But the challenge there being you're parking a fair amount of money for a fair amount of time. And since the client trust accounting rules are so precise, it can be a challenge to keep that money in a way where it is just sitting in the client trust account for years on end. But that is a strategy that some lawyers use.
You're right. We don't use it often, but I can think of one situation where we've been doing that, and that was an interesting one because essentially we tried to resolve this lien, and we're making, I thought, fairly reasonable offers, and they stopped responding to us. So we kept following up with them. They eventually stopped responding. And it's like, well, we're not going to keep bothering them. We're just going to park the money and hopefully they forget about it. And I think we're just over 2 years into the 5-year process here, but no word from them in the whole 2 years. And, 3 more years and then we'll be looking good. So we'll just have to wait and see.
Yeah. Well, Tim, I really enjoyed our lien conversation. I appreciate you taking the time to come on and talk through some of your strategies.
Yeah, thanks for having me. And, there's much more we could discuss another time on down the road.
Definitely. Well, and thank you for listening today. Please email us at podcast@coopers.law with questions, comments, feedback, and suggestions for who we should have on the show. Like what you heard? Share us with a colleague and leave us a 5-star review on your podcast platform of choice. To all of you doing justice out there, happy hunting.